Companies Act, Section 286, Obligations of Directors and Managers with Unlimited Liability. Section 286 of the Companies Act, 2013 imposes additional financial obligations on directors and managers of a company whose liability is expressly stated to be unlimited. This provision is significant in situations involving the winding up of a limited company, as it overrides the general principle of limited liability for certain individuals, based on their designation and contractual or statutory undertakings. The section ensures that those who held positions of authority and whose liability status was specifically set as unlimited either by the constitution of the company or under the provisions of the Act may be required to make additional contributions beyond what ordinary members are liable for, thereby enhancing creditor protection and accountability during liquidation proceedings. 1. Scope of the obligation to contribute further. When a limited company is undergoing winding up, any individual who is or has been a director or manager and whose liability is deemed to be unlimited in accordance with the provisions of the Companies Act, 2013, will be liable to contribute further to the assets of the company. This further contribution is in addition to any liability they may already have as an ordinary member, such as unpaid share capital or agreed financial commitments. The law treats such individuals, for the purpose of winding up, as if they were members of an unlimited company from the very beginning of the winding up process. This legal fiction ensures that they are subject to enhanced financial obligations to help satisfy the debts, liabilities, and costs associated with winding up the company. 2. Conditions and exceptions to liability. To prevent undue hardship and to maintain fairness, Section 286 provides specific safeguards and exceptions. These are designed to balance the need for additional financial recovery with reasonable limits on retrospective liability. A. Time-based exemption. A former director or manager shall not be liable to make the additional contribution if they ceased to hold office 1 year or more before the commencement of the winding up proceedings. This limitation recognizes that individuals who disassociated from the company well before its financial decline should not be indefinitely exposed to future liabilities. B. Exemption for post-tenure debts or liabilities. A director or manager shall not be liable for any debt or liability that the company incurred after they ceased to hold office. This provision is aligned with the principle of natural justice and ensures that persons are not held responsible for financial decisions or commitments over which they had no control or influence. C. Tribunal's discretion and reference to Articles of Association. Even where an individual qualifies as a director or manager with unlimited liability, their obligation to contribute further shall arise only if the following conditions are met. The Articles of Association of the company do not restrict such further contributions, and the tribunal deems it necessary to call upon such individuals to make further contributions, in order to satisfy the outstanding debts and liabilities of the company, including the costs, charges, and expenses involved in the winding up process. This ensures that the imposition of further liability is not automatic but is subject to judicial review and necessity, based on the financial condition of the company and the adequacy of existing member contributions. 3. Legal significance and rationale. The rationale behind Section 286 is rooted in the principles of corporate governance and responsibility. Directors and managers often exercise significant control over the affairs of a company, and where their liability has been defined as unlimited, they are held to a higher financial accountability, particularly when the company fails to meet its obligations. This provision aims to deter reckless or negligent conduct by individuals in senior management roles. Provide a secondary line of financial support for creditors and stakeholders during liquidation. Reinforce the seriousness of assuming an office with unlimited liability. Ensure that individuals who benefited from the company's operations in the past share in the financial burden of its dissolution where appropriate. For more details, contact us.